This is part 6 and the conclusion of property. Looking at tort liabilities, landlord and tenant tort liabilities. The tenant has a duty of care to invitees, licensees, and foreseeable trespassers. They may be liable for dangerous conditions as well. The landlord is liable for injuries occurring only in common and public areas or non-common areas under the landlord's control, and for injuries occurring as a result of a hidden defect or faulty repair. Looking at assignment and subletting, absent contrary language, leases can be freely assigned and or sublet. An assignment is a complete transfer of the tenant's remaining lease term. A sublease is a transfer for less than the entire duration of the lease. Assignee's rights and liabilities, and again, an assignment is a complete transfer. Assignee is liable to the landlord for rent and other lease covenants. They may also assign the lease, thereby breaking liability to the landlord, so they can continue to assign the lease. Subleasee's rights and liabilities, and again, a sublease is transferred for less than the entire duration. They are liable to lessee, not the landlord, unless the sublessee expressly assumes rent and or other covenants. So they are liable. The subleaser is liable to, the sublessee is liable to the tenant who subleases, not the landlord. Original tenant's rights and liabilities, even though privity of estate is broken by an assignment or a sublease, privity of contract is not, and the original tenant remains liable to landlord for contract covenants. Now, a landlord assignment, such as sale of rental property, here both the tenant and new owner are bound by the lease doctrine. The doctrine of attornment no longer applies. So where there is a sale, you have not agreed to be bound by that person, that's attornment, and then you can not be bound by the lease. Limitations on assignment and subletting, where they are prohibited, even though prohibited by lease, a tenant can still assign and or sublet the property. A landlord may then consider this breach and terminate the lease. Moving on to condemnation. A condemnation is a taking for a public use or because it is unfit for use. You have partial and complete condemnation. Partial condemnation is where part of the leasehold is condemned. Here the tenant must still pay rent. Where there's complete condemnation, the tenant is not bound. For housing and discrimination, you cannot discriminate in housing in regards to race, color, religion, national origin, sex, disability, familial status. Moving on from landlord and tenant to disputes about ownership in land. Looking at adverse possession. This is where ownership of real property is transferred to a person who exercises exclusive physical possession of that property for a certain amount of time. That time must be continuous. Under the common law, it's 20 years. May be different under statute. Infrequent use, such as use of a 3-season cabin, may be sufficient if it's consistent with that type of property. Again, a 3-season cabin. And again, it has to be for that amount of years by statute or common law, the 20. Tacking of time in regards to the continuous requirement, you may compile prior possessor's time to satisfy the common law 20-year or statutory period, whatever that is. It must be directly passed from the prior possessor to you. You must have privity with that prior possessor, such as blood, contract, deed, and or will, and not be hostile from the prior possessor. Now, time does not run against a disabled owner, somebody who's insane, is infancy, and or is imprisoned. Adverse possession must be actual, open, and notorious. This means that possession must be such that a reasonable owner would become aware of the claim. Possession must be hostile. For adverse possession, this is where you possess the land without the owner's permission and intent to claim land as your own against the claim of others. Majority of jurisdictions, it need not be hostile in the sense that it seeks to defeat the owner's title. Let me clarify that. Majority of jurisdictions do not require that possession be hostile in the sense that the possessor purposely seeks to defeat the owner's title. The intent of the possessor is irrelevant in many jurisdictions. Exclusivity in regards to adverse possession, it must be exclusive. Your adverse possession cannot be shared with the true owner. It can, however, be shared with another party. Again, for adverse possession, possession must be continuous, must be actual, open, and notorious, must be hostile, and must be exclusive. At the scope of the adverse possession, or scope of possession in adverse possession, you have constructive adverse possession. This is where a person enters under the color of title, where they believe it's a facially valid title. Here they actually possess only a portion of the property. Constructive adverse possession can give title to the whole property. Now, the amount actually possessed in adverse possession must be a reasonable portion of the whole. You can't have a tiny little section of it that you come in under color of title and then get 1,000 acres. You may get 1,000. You may come under color of title for the 1,000 acres and then get the little tiny 1 acre section off of that. Looking at below the surface scope of possession, the adverse possession. This is where the adverse possessor acquires rights to subsurface mineral rights. Looking at future interests, the adverse possessor acquires the estate held by the person who has legal possession at the time that the adverse possession begins. This means that the adverse possession period does not run against future interests that exist at the time that the adverse possession begins. But it does apply to future interests created from a fee simple absolute estate after adverse possession has begun. Moving on to under disputes about ownership of land, looking at the land sale contract. Again, this is under disputes, ownership and land. This is where formation of the land sale contract must comply with the statute of frauds, must be in writing, signed by it must be signed by the party to be charged, contain essential terms, meaning the party's property description and terms. An exception to the land sale contract in the statute of frauds is where there's pervasive evidence of a contract, such as you have payment of all or part of the purchase price, you have possession by the purchaser, or substantial improvements of the property by the purchaser. Rarely is detrimental reliance sufficient to remove the land sale contract from the statute of frauds. That is formation of the land sale contract. Looking at performance of the land sale contract. Performance is where you have marketable title, which is free from defects and or risk of litigation. Here, marketable title is delivered at closing. Marketable title, you have merger. Now, once the deed or marketable title is delivered at closing, the purchase contract and the deed merge in the deed controls. Defects in the title rendering the title unmarketable include the title is acquired by adverse possession, future interests where the holders of such interest have not agreed to the transfer, or there's a private encumbrance such as a mortgage, a covenant, an option, or easement, the violation of a zoning ordinance, or where there's a significant physical defect such as an encroachment on the land that is incurable. That is a defect those are defects that render the title unmarketable. And that completes part 6 of property.